Hello, welcome, and thank you for joining us for this Contracting in the Digital Age. This webinar is presented by the Digital Commerce Committee of the Business Law section of the Law Council of Australia. My name is Susanna Wilkinson, and I'm the chair of the same committee. The format today will be a three-panel discussion, each hosted by a member of the Digital Commerce Committee. Each panel will consider smart legal contracts in increasing levels of detail and sophistication. So whether this is your first time hearing about smart legal contracts or whether you've been on this journey for a while, hopefully we'll have something for everyone today. You've received the speaker profiles, so I'll stick to some very brief introductions before each of the panel sessions. To get started, let's give a brief introduction of smart legal contracts. We've got a lot of content to cover today, so I will be brief and I'll leave the limelight for everybody on the panel sessions. But in a nutshell, to introduce, smart legal contracts are a form of digital contract. They're legally enforceable contracts where part or all of the rights and obligations recorded in natural language are also represented using code. SLCs will provide an opportunity to manage business relationships more efficiently, to generate valuable data and analytics. But we need to understand contracts as a vital part of society, and most of you in the audience as lawyers will understand that, and understand that they enable trust and protection under the law. But the way that we interact is changing with an increasing reliance on digital technologies and automated processes. That's nothing new. So it's easy to think about smart legal contracts as the new frontier, the evolution of contracts. But they're also just a necessary step for the law to keep pace with the increasingly digital world that we live in. In the last 12 months, this conversation has hit the mainstream. We've seen the UK Law Commission undertake detailed project on smart legal contracts and publish advice to government on the enforceability of smart contracts under the laws of England and Wales. Closer to home, we've got the Senate Select Committee here in Australia exploring how to position Australia to become a leading technology and financial centre. And this necessarily touches on digital assets and issues relating to smart legal contracts. So the aim of this session is to explore some of the key features of smart legal contracts that we need to understand so that we can sensibly address any issues to adoption and harness the digital transformation of contracts. This is not a job for a small group of people or any single firm. This is an industry-wide development that requires collective wisdom and collaboration. So jumping straight on in, I'd like to introduce the first panel. And as I said, you have details of each of our world-leading speakers, so I won't go into too much information. But first panel, if I could invite to the screen Dr. Mark Giancastro, who's a lecturer and practicing lawyer and a member of the Digital Commerce Committee, and also Tom Skivington, legal associate at Square Peg, which is a global investment fund. And this first panel will touch on some of the core introductory concepts around smart legal contracts. Welcome, Mark and Tom. Thanks so much for joining us.
Thanks, Susanna. All right. Again, big thank you, Susanna, and to everyone else in the Law Council for putting this together. It's been no small feat, and really, really excited to be talking to you all about this really important topic today. So going to kick off with just briefly introducing Tom. And Tom, I'm sure you can speak more to your experience, but Tom has actually worked in private practice, very much in the digital commerce realm for a long time. He's now working, of course, in corporate in-house in an in-house counsel role with Square Peg Capital, who have interests all over the world, and from what I can see, a very large portfolio of holdings. So knows a thing or two about digital commerce and smart contracts in particular. So I think maybe we'll try and keep it light and have a bit of a conversation with you and with each other. But Tom, if it's all right, after maybe just speak a little more to experience, smart contracts, what exactly are these things for those in the audience who have no idea what these things are? So why don't we keep it light to begin with?
Great idea, Mark. I don't think I need to go into any more detail and experience. You've nailed it. Other than to say I've been working in the blockchain crypto space for about 7 years now. So been around these concepts for some time. To go into the high level, what is a smart contract? I think Susanna covered it really well, but to go into smart contracts and smart legal contracts, we really need to understand that a smart contract is really just any computer code that generally resides on a blockchain and that executes some predefined function. And so to sort of zero in on the key feature of the types of smart contracts that we're going to talk to today, their key feature is that they are blockchain based. And so to understand a blockchain based smart contract, we really should very quickly go over, okay, well, what is a blockchain?
Sure.
And super briefly, because we don't have time, a blockchain is just a decentralized distributed ledger book, effectively, that operates on a computer network secured using cryptography, and that can only be altered through a consensus mechanism that involves that blockchain's users. So I guess to be a little bit more specific, each blockchain, is made up of individual time-stamped blocks that contain text and code. Those blocks record and collect groups of transactions and smart contracts together that are entered into by users of that blockchain using cryptography. And then each block which contains those transactions is linked together to the preceding and subsequent blocks. And that complete ledger is a chain of all of those linked together blocks, where any change to an earlier block is just automatically rejected by the network. And so the context of why the blockchain is that important connecting layer with smart contracts, a good analogy is to think that, okay, if smart contracts are software that run predefined functions, then the blockchain underlying them is like the operating system that allows that software to run effectively. And so effectively, blockchain is just the infrastructure layer that allows smart contracts to work. And it does it really for two main reasons. The first is that code which is embedded in a blockchain can be executed automatically without interference from any third parties. The second is that it removes or reduces the need for each of the parties to a smart contract to maintain their own separate ledger of the transactions that they're entering into, so that once that smart contract is executed, the blockchain record of what has or will happen just can't be altered.
So can I just jump in, Tom? So to water it down a little bit more, when you say, because you mentioned or describe the blockchain as a distributed ledger book, so I think most in the audience will be familiar with that concept of, the orthodox ledger book, the old leather-bound dusty record with all the comings and goings and transactions occurring through a particular business. So basically, it's still that, except rather than having one book, locked in a drawer in the office in the business, now everyone involved in this particular network, or across this network of computers, can see that ledger book, has access to it, can amend it only, however, upon consensus of those users. Would that be a fairly accurate way to describe, just to try and water it down again? I know because it's easy to get bogged down. Just for people.
Perfect. Yeah, perfect. That's exactly right.
Okay. Yeah,
and
you did say it was difficult to tap into as well, didn't you? So I think we'll probably talk more about that and some of the more complex terminology later. But yeah, what's just in terms of, you mentioned the infrastructural basis, what, for those who are still trying to grapple with the idea of how sort of things end up on the blockchain, what are we thinking there?
Are you talking about how smart contracts are actually used on a blockchain? Is that what you're getting at?
Yeah, maybe perhaps just when we're trying to explain what smart contracts are, we can just touch on that. I know that would be built on in panels 2 and 3, but maybe we should just very briefly touch on that, do you think?
Sure. I think the fundamental point is that without a blockchain, a smart contract is not that much different to code on a website, which says that if you do X, so send me money, the website will automatically do Y, send you some digital good. In that sense, you have to trust that that website has coded that function correctly so that you'll automatically receive Y, that it is actually going to do that, and that it's not going to change after you've done X but before they've done Y. Having the smart contract on the blockchain removes those risks because you can be assured that the smart contract cannot be changed. There's a clear view of what that contract entails, and there's no trust between those parties. So it's a trustless transaction.
Excellent. I suppose for those wondering then, and again, I realise for those listening that is very much a crash course, but we will build upon some of these concepts in later panels. In terms of these smart contracts then, Tom, they can be used for a number of things. I'm sure most of our audience are wondering what the hell these things can actually be, how they can be practically applied. I've got a few examples in mind, but I know you yourself in your line of work have a particular exposure to things such as, and I'm sure people have heard about these buzzwords in the media, DAOs or DAOs, DeFi or decentralized finance. Maybe could we possibly touch on a couple of those use cases for people just to see and conceptualize, how these things actually do work in practice? Then perhaps I can chip in some examples too.
Yeah, love it. Great idea. So a DAO, which you mentioned, or a decentralized autonomous organization, is one of the main use cases for smart contracts that I've been involved with personally. And it's effectively, just a very quick overview, a blockchain-based organization that at the moment is one of the most popular structures for crypto native businesses. And smart contracts really form the backbone of every DAO that's out there at the moment, because they're used to facilitate, smart contracts that is, are used to facilitate the issuance of interests in the DAO, normally following receipt of an initial subscription amount for people who wanted interest in that DAO. The staking of interests that have been issued in that DAO to allow things like the voting from the members, and then fundamentally things like spending the money that has been contributed to the DAO either through a consensus mechanism of those members voting. So it's a lot like a company or a partnership where smart contracts facilitate all of those ordinary interactions that a company would normally have, issuing interests, voting, all that type of thing. DeFi is another rabbit hole that we won't go into too much detail on. But again, decentralized finance, or DeFi, really used to describe an incredibly broad class of blockchain and smart contract protocols, which effectively, just as the name implies, decentralize traditional investment banking and lending transactions. And so one of the most popular applications of a smart contract in DeFi is a lending protocol, which allows users to transfer normally a crypto asset like Bitcoin into a smart contract. And that smart contract holds that crypto as collateral and then will automatically distribute interest from the borrower to the lender at predefined intervals. So those are probably the two main examples of smart contracts in that very specific industry, but they're being used a lot. Do you think, Mark, could you go into some of those more like real world examples that you're probably seeing day to day in the media, especially more so now?
Yeah, sure. All right. There are quite a few, as we both know, and I'm sure some of our listeners have probably come across some of these use cases. If not, you certainly would have heard of things like Bitcoin and Ether and these other cryptocurrencies out there. So you're probably more familiar, those listening, with some of these infrastructural bases and some of the use cases already without realizing it. But I think some of the more common examples, particularly in this smart legal contract context, are mainly in the finance and insurance sectors. I think you're seeing a lot there. So the classic example that's being explored and actively investigated as well for application in the insurance industry is the smart insurance contract. So let's take the example you used, Tom, and I think that's an important point too about decentralization. That's essentially the idea behind smart legal contracts is we're actually taking those intermediaries, those traditional intermediaries, out of the picture. We'll probably talk about that a bit more shortly in terms of the potential benefits, if I can phrase it that way. But a smart insurance contract is a great example. So for those listening, the most basic example, and it's already in fact been applied, is an insurance contract, which is, as Tom said, coded obviously in both, originates in natural language and then is coded into programming language. It's entered as a smart contract onto a blockchain network, and then that's of course where it will reside. But the difference between, and again this is something we'll touch on the end of our panel, a traditional automated agreement and a smart contract existing on a blockchain is that a smart contract will not just perform automated functioning, but will actually execute its own terms and effectively oversee its own operations without any human involvement, potentially at all. So the smart insurance contract would work like so. It would be, as I said, posted to the blockchain. Let's say the term is we're insuring some rural property against, say crops or grain or something like that, against extreme heat. The policy says you will receive the insured sum if the temperature for 7 consecutive days in, let's use my home South Australia, exceeds 35 degrees Celsius for more than 7 days. So what the smart contract could do, and this is what's quite extraordinary in terms of their capabilities, is it could actually liaise directly with the Bureau of Meteorology, for example, and constantly draw, and I mean literally second by second, to the minute data on temperature in South Australia. And then the second that it exceeds 35 degrees for 7 consecutive days, which is the activating trigger in the contract and the insurance policy, that insured sum will be automatically paid into the nominated account. What that means is that there's no broker or insurer actually having to do anything. The contract has itself supervised and executed its own terms, and that's through the use of something which you'll hear more about later called an oracle, which is essentially a line of software or programming within the contract itself. That's what enables it to draw information from third-party sources. So in this case, the Bureau of Meteorology. That's quite extraordinary because now most of us would know, of course, if you had an insurance claim in this way, you'd be manually checking the weather for 7 days, and then you'd be calling or contacting your insurer, or potentially nowadays more likely lodging a claim online. But that would involve, again, a fairly intimate level of human activity. So that's probably one good example. Some other brief ones you might have again seen in the news. Some large retail giants such as Audi are using blockchain-based infrastructure and smart contracts to manage their supply chains. So they're literally managing, for example, the manufacture and distribution of their goods all the way from the factory through to the retail shop shelves, all through smart contracts. So again, there's very little human oversight, which on one level I suppose is a bit scary, but on the other level, it's quite interesting because there's not only saving money, but it's far more efficient than human hands. So there are a couple of examples. And I think, Tom, we were talking the other day about land titles registries using blockchains to manage enormous volumes of data. Lots of benefits with doing that, which again we'll touch on later. But there are, I think, some of the more sort of mainstream examples that you'll see, in the media.
Yeah, I think those are great ones, and a good example as well of how smart contracts can increase in complexity when they're able to draw in data using oracles, which we'll go into more detail on, or other panels will go into more detail on later. So I think those examples are great, Mark, but I think now that we've covered sort of the what and the why, we should go into more detail on, all right, well, what are the benefits other than the ones we've talked about? And then what are the risks with actually using smart contracts? Do you want to make a start?
Yeah, definitely. All right. Well, gee, there's so many. Again, for those listening, you might be thinking, again, there is a lot of terminology involved and it can be a little complex, but effectively, if we think back to the really useful explanation, Tom, that you gave earlier, this is essentially an automated agreement like any other, except that it's now got incredibly advanced algorithmic capability and it can perform functions which are far more complex. But alongside those benefits come a number of other benefits, such as, for example, heightened level of security. These smart contracts operate, again, as Tom said, on the blockchain. So it's on this distributed network. That means that that particular contract, in theory, exists across a number of what we call nodes, which is effectively a computer, across a network of computers, potentially worldwide. What that means is it's actually quite resistant to criminal activity because there's no longer a central point of attack. If you wanted to infiltrate a smart contract, you would not only have to do it on this computer here in South Australia, but if you have a node existing somewhere in Asia, you would have to try and hack that copy as well. It's actually incredibly resistant based on the fact that it is decentralized. So it's very different to your traditional ledger book, for example. You break into the office building, steal the ledger book, and there's everything. That doesn't happen with smart contracts. So that's one potential benefit. Another would be that they're incredibly efficient. So not only do they execute their own terms, but they actually will, and I suppose this is a related, again, I'm going to call it a benefit, but it could be perceived as a drawback as well. But you're taking a lot of the people handling out of the process. So without these intermediaries, and the traditional ones, of course, are banks, insurers, and even lawyers, you're taking them out of the equation because the contract does all. I think the famous adage in the computing world is, code is law. So it will do what you say or what you program it to do, and no one else will have anything to do with that process. So I suppose the fact that no one's tasked with oversight means that you can potentially save costs, all those little transaction costs associated with having intermediaries involved.
And Mark, I think we had sort of talked before about that is a great benefit, that efficiency. But the flip side of that is that that can be a real risk because, automatic and instantaneous performance of a contract sounds great, but is often quite different to what we actually do in practice. We, speaking from SquarePeg's perspective, often excuse, and as I'm sure everyone does, really minor or immaterial breaches of contracts by just doing nothing about it. Whereas that is rarely an option with a smart contract, because if there is a trigger that involves a breach, no matter how minor or technical, the smart contract will execute its predefined function on that breach. So
that's perfect segue, Tom and Mark. I'm going to cut you off there. Thank you so much for that exploration into sort of the technical aspects of it. As you said, I think the what, the why, some of the benefits and the risks. I'm going to introduce, so thank you both for your time. I'm going to introduce the second panel. We're really lucky to be joined by two giants in their field. We've got Dr. Aaron Lane, RMIT Blockchain and Innovation Hub Senior Lecturer. He's a research fellow, special counsel, and a member of the Digital Commerce Committee. We're also joined by Professor Marta Poble, Professor of Law at RMIT. She's a global expert at the intersection of law, politics, and technology. It must be a very interesting place to play. So thank you both for joining us. We've heard about the really technical aspects of the smart contract. How does the tech work? How does the code perform? Understanding the benefits of that automation. What I'm really interested in, hopefully this panel can help. How do we wrap the law around that technology? And I understand from this section, we're going to hear about incomplete contracts and some of the issues around dispute resolution of how we unwind when things actually start to go wrong. So without further ado, hand over to both of you. Over to you, Aaron.
Wonderful. Well, thanks so much, Susanna and the team for putting on today. Marta, great to have you with us. Marta and I worked very closely together. We've written a couple of papers together that we're going to draw on, I think, as part of this discussion today. But Marta, I guess I just wanted to perhaps go back a few steps, given that we're going to talk about dispute resolution as it relates to smart contracts. I wonder if we can just perhaps step back a couple of decades and just chart, where did we come from here in terms of online dispute resolution? Because this has been something now for some time, and it's evolved, and you've done particular work in this space. So I just wanted to get your sort of sense of where have we come from and kind of where are we going in this conversation.
Thanks, Aaron, and thank you everyone for having me. It's a pleasure to be here in this panel. So yeah, let's go back a couple of decades ago, because every ecosystem has its own dispute resolution rules. We learned that from Elinor Ostrom, Nobel Prize of Economics, a few decades ago as well. So the internet also brought its own dispute resolution system in a way. When think of digital commerce, creating a new environment for millions of transactions online. This new environment needed new dispute resolution systems that were more agile than traditional courts. So with every step of the internet, we've brought new forms of dispute resolution. I'll give you an example. When PayPal was born and transactions started to happen there by the millions, new disputes could emerge in that ecosystem. So eBay, PayPal created their own dispute resolution rules. Part of them were automatized, so for the most simple and repetitive ones, there was a procedure they created. And for the most complex ones, new systems of mediation and arbitration in that particular space would emerge as well. So, and obviously, there were also for consumers the resource to traditional ways of dispute resolution, arbitration, and the court systems. But what I mean by online dispute resolution is the fact that with every new online service provider, electronic commerce, whatever it is, the Wikipedia, complementary dispute resolution settings and procedures have come along to deal with those disputes in particular. I'm not sure if I answered well the question, and Aaron, but the idea is that with every new environment, new dispute resolution rules will emerge.
Yeah, absolutely. And I think we can come back to that question a bit later when we talk about kind of some of these new possibilities. We heard from Tom and Mark before we're discussing oracles. They're obviously a key input in the functioning of smart contracts. But what's your take? Like, can you give us your sort of definition of an oracle, and why is it called an oracle anyway?
Aaron, you remember how much fun did we have writing this paper on oracles, because it's a really interesting topic. Oracle is a metaphor, actually. Oracles are a very ancient informational device. We can track them back to the Athenian democracy, where Athenian rulers would consult the oracles to check whether they would engage in warfare or not. So there were highly valued informational devices that would guide behaviors in the Athenian democracy. So then this notion was retaken by computer scientists, especially again with computers working online. So an oracle, again, was a piece of data, an informational device that could connect a computer to the external world. In the blockchain, the metaphor still holds. Smart contracts running on a blockchain do not have access to external data per se, unless there is an interface that connects the external world of data to the on-chain transactions. So when we say that smart contracts call to an oracle, I think there was a question about it on the chat already. There is a line of code in the smart contract that will call an external source of knowledge. It can be, as I think Mark mentioned, the Australian Bureau of Meteorology providing data on temperatures. It can be a network of sensors providing other related data on things happening on the environment. Or it can be a price or an index if we are in the decentralized finance. But somehow there needs to be this interface between the external oracle, and we use the metaphor again to refer to a trusted source of knowledge, and the internal smart contract. Sometimes this interface, it's also called oracle, which can be confusing. So I would say, let's call the interface the oracle service provider. There are companies now in the blockchain doing that. For example, Chainlink is an oracle service provider that connects smart contracts with external data sets or pieces of information that are basic, that are highly relevant, because otherwise the smart contracts would not be able to execute themselves.
Yeah, exactly. And I guess the other point to make is that it's a way of not putting everything on chain. you know, not having to, you know, put every sort of piece of information into the smart contract sort of to start with, where that information might not be known, it might be contingent on some sort of event. You know, we need to be able to verify that. But I think two things kind of strike me sort of here in this discussion as sources for risk and sources for dispute. And these become, I think, drafting problems as well for kind of front end contract lawyers, in the sense that parties will need to agree on who that oracle will be, or what that oracle might be, and whether they want to set up their own. It's kind of becomes a make or buy decision. You know, do you set up your own network of, say, IoT devices and put them inside the shipping containers to monitor the temperature or something, or do you outsource that to, you know, as you were suggesting, a third party provider? Those are both quite, you know, reasonable decisions that might have, you know, costs or benefits in different situations. And I don't think there's necessarily a hard and fast answer to that, but there seems to me to be legal risk involved in both of those situations, where you know, on the one hand, you know, if you've got a third party provider, well, how do you deal with the fact that the third party provider systems break down? Or what happens if those IoT devices are suddenly not recording the temperature accurately? Or what happens if there's problems with some sort of price feed? You know, what about if they go insolvent and you've got to update the code? So I think there's a whole sort of realm of legal risk there, just in deciding what the oracle is. But there's also, I think, a realm of legal risk where, and this kind of leading into disputes about where you've got this kind of oracle problem, where something kind of goes wrong and malfunctions. Have you got any sort of further thoughts on that?
Yeah, the oracle problem is basically not even in Athens oracles were infallible, right? So oracles, to stay in business, they need to be accurate. And that applies to any type of oracle. Even machine learning, which uses lots of oracles in their training data sets, have the problem of fallible oracles. And I think Alan Turing was one of the people who, when writing about oracle machines, would say that if a machine is infallible, it will not be intelligent, because the source of being smart and intelligent, even in computing science, is the capacity to learn from mistakes. So how does this translate to our scenario of oracle problems? As you said, Aaron, many things can go wrong with an oracle. The IoT devices can stop functioning for whatever reason. Even the weather station of the Australian Bureau of Meteorology can be affected by flooding or bushfires, and it doesn't give the particular temperature in that specific area. Or even though the oracles work well, there is some bug in the oracle interface that didn't capture well those systems. So there's many ways in which the oracle environment can go wrong, and that will obviously trigger new legal disputes. So what happens when the oracles cannot be utilized? How didn't trigger the smart contract as they should, so on and so forth. I think we are here before new legal scenarios, and that's why the smart contracts, the smart legal contracts, need also be very careful on the choice of oracles. What happens if those oracles do not trigger the transactions they should? Which dispute resolution services should be invoked if that happens? And so there's lots of decisions before deploying a smart legal contract that need to be taken at the oracle level in particular, and which are probably as complex as the other clauses of the legal contract itself.
Yeah, absolutely. And these problems are more than hypothetical. I mean, in the DeFi environment, we've seen exploitation of you know, I guess oracles that are relying on smart contracts that are relying on price feeds. So the oracle in this situation, it's a a collateralized loan contract, and it relies on a price feed, and that's what the oracle is. In that scenario, you've got a price feed coming in. There's been cases where people have been able to manipulate, take out a loan, manipulate the price, and effectively arbitrage, and take out swathes of liquidity sort of out of the system in a manner where is it stealing? No, it's not. But it's certainly taking advantage of this problem, and I guess underscoring the need for those oracles to be robust and to decide, well, what time period are we talking about here? As Mark and Tom were talking before, you could record second by second, but that's a lot of data. So do you average it over a 5-minute interval, or an hour interval, or a day, or a month? What's the how do you decide on that? I think that's a problem going forward. But these are not sort of hypothetical in DeFi land. These are sort of supremely important about how to do that. The other, so I think that's one realm as I see it of kind of the legal risk. The other main one, I actually think is a general point, not really just about smart legal contracts, but all contracts, and this notion of incomplete contracts, which kind of comes out of the the law and economics sort of literature. This is the idea that we can never really agree. Two parties are coming together to make a deal. The contract that is expressed, whether it's sort of written down or orally or whatever it happens to be, the agreement that is formed between those two parties will never be fully complete. And it's not fully complete for a number of reasons. The first is just a matter of knowledge. We don't know all the future states that could possibly be. The second is that we don't know all of the sort of scenarios to plan out. We also have cost implications. Lawyers are expensive, and so we're not going to plan for these things that are really remote. And so for all of these reasons, I think we're going to get to the point where there are things that we just haven't thought of, or there are things that we thought of but didn't do because of time and cost. And so I want to, and we're getting to the end of this this portion, Susanna. But what are the possibilities, Marta, as you see it, for smart legal contracts and disputes? And perhaps you can tell us about some of the new ones that are emerging.
Yeah,
Yes.
I will ask you to try and answer that quickly, Marta, if you can. We've got the next panel due, so if you can give your short answer, that'd be wonderful. Thank you.
Yeah, Aaron, to make it short, smart legal contracts are not complete. I fully agree. There's always space for openness, and that's not just smart legal contracts. Any contract in law has this open texture. Not everything can be anticipated. In the blockchain space, there's been a burgeoning area of startups such as Kleros, for example, or other dispute resolution service providers, such as the Aragon Court, that come hand in hand to deal with these disputes that inevitably, because of the open texture of smart legal contracts, will occur. And as I said at the beginning, with every layer of the internet, new dispute resolution services have appeared. That's also the case in the blockchain space. So for disputes arising from incompleteness of smart legal contracts, services such as Kleros or the Aragon Court, based on crowdsourcing of jurors in that space, based on some game theoretical assumptions on how these disputes should be resolved, will also provide an environment for dispute resolution of smart legal contracts. And if you want to learn more about this, please Google Kleros or Aragon Court. Will give you more details on how crowdsourced jurors try to resolve these disputes.
Thank you very much. Aaron and Marta, I'm going to have to stop it there, but thank you both for joining us. And it was really interesting to hear, using the example of oracles to highlight that the interface between the possibilities of tech malfunction and legal risk. And Professor Marta, I really liked the way you said that the law has evolved to deal with new applications of the technology. And I think that's something that we're going to look to explore a little bit more in our third and final panel session for today, which is how can we use contract law to really manage these risks? I'd also welcome, please use the chat function. We won't have time for Q&A, but it will help us shape future sessions if you can put any questions you have in the chat. And so now it's my pleasure to introduce the final panel speakers. We've got Natasha Blatcher, who's Managing Director of Sterling and Rose, and also a member of the Digital Commerce Committee. And we also have Angelina Gomez, who is Senior Counsel at Clifford Chance and a former barrister of the New South Wales Bar. Welcome, ladies, over to you.
Thanks, Susanna, and I'm very pleased to be speaking with my good friend Angelina, who also happens to be a world-leading expert on digital assets. Okay, so we're going to be a bit of a canter through because we haven't got much time, but let's pare it back and go back to a smart contract is different to a smart legal contract. Why is it different? Because a smart contract technically is just self-executing code on a blockchain. If this happens, do that. It's very simple. A smart legal contract is the next iteration of the thing that we as lawyers do. It is that the rights and agreement, it is the parties agreeing, coming to a consensus. So the next iteration of contracting is a smart legal contract. A smart legal contract beautifully is a mechanism to deal with some of the problems that we've heard about, the risks, the oracle problem. A smart legal contract allows us to pair natural language, the thing we do, we speak, with code. So let's start off, Angelina, if we could, and talk about some of the mechanisms that are floating around of how we can use the next iteration of contracting, smart legal contracts, to be able to mitigate some of these risks that we're talking about through adding these automated functions of smart contracts.
Well, thanks, Natasha, and it's good talking with you as well. Natasha and I spend a lot of time talking about this, and a term that Natasha and her team have come up with, I think is actually invaluable in explaining this. So I think as lawyers, we all know the principles of contract, contract 101. Now, how do we bring that elements of contract and all the precedents in there with code and the automation, certainty, cutting out the middleman, the advantages of code? How do we combine that? And the term that Natasha has come up with, I think really describes this well, is a conjoined clause. Now, what that means is you have a meeting of natural language. So the words that we use in a contract on paper, if you will, combined with code. And you put that two together. So in effect, you have the words of a term and its operation as described in a code combined. And what you can do is put in there a hierarchy. So a court, let's say there's a dispute, you go to a court and the court goes, well, what is the intention of the parties? This is important. It is described in the natural language. It's evidenced in the code. And in that agreement, you can put the primary, the hierarchy, the first thing the court needs to look at is the natural language. Now, the court will look at construction as a whole, but having the intention of the parties put in and having that understanding that natural language is the priority, that establishes the relationship. Everyone knows what's happening when they're going in. And that combination, essentially, this sort of hybrid, if you will, is what we see as the future of smart legal contracts. Natasha?
So this is where we get to, is when you become a digital asset specialist, and you'll hear some people now saying every lawyer needs to become a digital asset specialist, is you realize that code is brittle. And a lot of the solutions that are coming about, they're wonderful for automation, but they do not have the ability to deal with the nuance of the concepts of reasonableness, the concepts of things like if a contract is running, a smart contract is running, it accrues data over time. Who owns that data? I've just seen things come into the chat where people are saying, well, also choice of jurisdiction. I'll add some more questions here. Okay, privacy law, cybersecurity requirements. These are rules. And when you just run an automation or a smart contract, a lot of the rules are actually missing, and the ability for parties to clearly state in a certain way that lawyers can understand, and members of the general public and consumers, understanding that consumer law is a really high bar of the level of certainty and clarity as to what the parameters of a contract have to have. We need to get better at marrying up code, smart contracts, inside the belly of what we do as lawyers, what we call smart legal contracts. So Angelina, can these things, there's not that much judicial decision. Can smart legal contracts be considered legally binding?
Well, yes. So there is a recent decision, and I will recommend this to everyone. I'm just going to get the citation. So it's COINE, spelled Q-U-O-I-N-E, Pte Ltd, and B2C2. It's by the Supreme Court of Singapore Civil Appeal 2020. And basically it was dealing with cryptocurrency. And what it actually found, and this is the interesting thing, because it was then upheld on appeal, that you can have a smart legal contract. So the automated part of it can hold up to legal enforceability. And that's key. That's really important. Now, whether that covers all the aspects of the legal issues we need to consider, that may not come up with the automated part. So you would need natural language to cover, as Natasha was saying, governing law, jurisdiction, venue, dispute resolution, force majeure. And just to address a point that was raised in an earlier part of the discussion, let's say there's a failure with an oracle. So the IoT device fails. It's, something happens, it's not registering the temperature of the goods. Then allowing this hybrid natural language conjoined clause with code allows for you to create for your client a fallback. So if the automation doesn't work, for example, does not work, then you're allowed to still meet your contractual obligations by manual means. Mm-hmm. So there is that fallback that you can put into the contract, so it just all doesn't go up in smoke. So it doesn't automatically result in a termination. It results in a fallback that you can then have an ongoing relationship. And this is important because when courts interpret a smart legal contract, they're going to look at business efficacy. And this is key to that. Sorry, Natasha?
I don't know how much time we've got left, Susanna, but I think there's some really big conceptual ideas we'd like people to leave with. And one is
6 minutes, Natasha. 6 minutes.
Thank you very much.
It's a world.
Okay. Here's your big conceptual issues. One, the contract itself is a really interesting proposition to act as a packet of data to assist parties in their general business transactions. So we have that in its analog form now, but a contract can do so much more if you start to, as was pointed out earlier, you can make it have an API call to hear a piece of information. So the contract's listening to the world and pulling information back from the world into the packet of the contract. But you can also make the contract send information back out to the world. Now, if you're a big business, or some of our clients can have up to 1 million contracts or more, suddenly, because the contract is now machine readable, it allows the business, the directors, the board to suddenly have oversight through a machine readable format and data about the performance of their business. So this is massively exciting to clients. Where is the bottleneck? The bottleneck is to do what Angelina and I have just described, where you are merging natural language and computer code in a really good, strong way, is really difficult because machines are not really good at learning natural language yet. So what do we as the legal profession need? We need to have applications that allow us to be able to write natural language that we understand, and we need something second. And this is the last point we really want to drill into about big conceptual questions. It's what Tom was talking about, the tech stack and the blockchain as a part of the plumbing that underpins these new smart legal contracts. So we as a profession have to ask very serious questions about, is that layer critical infrastructure? And if it is critical infrastructure, who should be responsible? Does that need to be regulated? Is it something that we would leave just as public permissionless? Is it a proprietary solution? Will we be meeting our director's duties if that part of the stack is not looked after nicely? Angelina, do you have any thoughts about what you think should be in critical infrastructure for contracting?
For me, one of the issues that we've been looking at, and you've raised this, is the issue of privacy. So privacy, data control, and because I'm a very big believer, and I think a lot of us on this panel are, that data should only be collected for the minimum required for your operations. And that's key, because with all IoT devices, someone's going to have to control this data, and it's data being used, it's personal information, it's product information. How is that controlled? Is that, do you have sufficient cybersecurity? Is the platform you're using in order to host your smart legal contract as secure as humanly possible? But just one important takeaway is, when you're doing this, please, there's data being accumulated everywhere. You only need what you absolutely need, and it's important that we keep it that way, because there's going to be much more on privacy law coming up, and you just want to be on the right side of this. So that's my takeaway. If nothing else, it's don't collect data for the sake of collecting data.
Amazing. So last thing that we wanted to mention in this panel is to say, think of your contracts in the future as derivative digital assets. So if I use a contract, just say it's a project contract or a joint venture contract, or a managed service agreement that runs a hospital, or it's something that runs an airport, and that contract is connected to the ERP systems of both the parties. It's a single source of truth. It's collecting data. That actually becomes a beautiful piece of information that somebody can use later on to be able to rebuild a project. So we need to start thinking of these contracts in a different way. And I want to leave with a thought about contracts and networks of complexity and oracles. So when your contract has been running, and let's say this is happening in 3 to 4 years, over the next 10 years, our contracts will increasingly connect outside of that static piece of paper to other pieces of information. And sometimes contracts will now be connecting to other contracts. Okay, so contracts will become connected to other contracts, and they will feed information in and out of each other. Think about a supply chain. Think about carbon units as they pass through. Think about this need for reconciliation and the impact that has on compliance if you're able to actually have a single source of truth and a mutable record of the contracts. So complexity networks also require really high standards. We're dealing with really critical information, we're dealing with contracts, and we as a profession need to pay attention to the platforms that are dealing with our critical asset. Thank you. Any last words, Angelina?
The only thing I just want to say very quickly is, a contract, as Natasha was saying, a contract is a living organism. So as lawyers, we've got to think of it as it's a living, breathing instrument, and more so now with smart legal contracts. There's code, there's text, and something we haven't mentioned yet is equity. So there's equitable obligations, fiduciary obligations, estoppel that sit under this. And, really, this is why the transfer division came about. So you've got legal, common law, you've got legislation, and you've got equity feeding in. These are all crucial. So it's an exciting time, living organism contract. A lot of fun.
Thanks, guys.
Thank
That's wonderful. Thank you so much, Natasha and Angelina. I never get tired of hearing you both talk about these things. You do a great job of bringing the complex to the masses. So thank you for that. And it is really important, that part of joining, you know, the code with the natural language in a really strong way. So the purpose of this session today across those three panels was not to scare you all away. There are really, really exciting opportunities, and I'm also delighted to introduce Dr. Adrian McCullough, who will make some closing remarks before we close today's session. So he has a PhD in IT security. He's got computer science and law degrees, sits on a wide range of committees internationally relating to the application of blockchain technology, including smart legal contracts. He's an all-round Aussie guy and has lots and lots to say on the matter. So over to you, Adrian, for the last 5 minutes, and then I'll do some thanks and close the session. And please, everyone, a reminder, keep your questions coming in the chat because they'll be really helpful for us afterwards. Thank you.
I'll be very brief. We started off with what is a blockchain, a distributed ledger technology that is cryptographically connected and runs on various types of consensus mechanisms. The DAO was mentioned as being a smart contract structure. It is interesting that the Bragg report, Senator Bragg's report, came down, I think, about 6 weeks ago. And I was surprised that the government responded in less than 10 days. And one of the aspects of the DAO report was that the government does intend to further investigate the issue of DAOs. There's only one jurisdiction in the world that recognises a DAO at the present moment as a legal entity, and that is the state of Wyoming in the US. We then moved on to dispute resolution. I found this a fascinating discussion. I think what I took away from that discussion is that code is not law. Code can have errors, even with oracles. Smart legal contracts are nascent technology, so care still needs to be undertaken. And we then moved on to incomplete contracts. And a lot of aspects of incomplete contract revolves around what's called non-deterministic language. When you look at the Coin case, which was presented in the last presentation, you look at it and the court noted that the so-called smart legal contract that was running on deterministic language. And as lawyers, we use a lot of non-deterministic language in our drafting. Reasonable time. How will a computer actually deal with the concept of a reasonable time? And as lawyers, and it was pointed out in the dispute resolution discussion, that it's not possible for a lawyer to go through every combination in a contract. You just won't finish drafting the damn thing. So, you know, we do use non-deterministic language, and that's where a lot of these issues will arise in the near future. I also found the last discussion very good, especially dealing with, I noticed one of the questions was that I go on about over the last number of years that smart contracts are neither smart nor a contract. Smart legal contracts are different. I still don't think they're smart. Okay, it depends on what you regard as being smart. They're not intelligent. They are based on deterministic language, and so they do rely upon a lot of pieces of data so that they can process and give a result. And I like the term, and I've not heard it before, that Natasha used, co-joined clauses, whereby you have a natural language contract in combination with code. And, you know, this whole point of whether code is law originated by a very famous Harvard professor, Lawrence Lessig, in his book of 2009. I also like the idea that, you know, a lot of this stuff is running on critical infrastructure. That issue has not been adequately researched, in my opinion, and I think that's going to be a very interesting aspect that needs to go forward. So in summary, smart legal contracts do exist. They are based upon a legal contract that is in existence, and it's the deterministic language in such a contract that can be re-encapsulated in code on a blockchain, but errors can occur. And look, this is really nascent technology as far as I'm concerned, and further research. And it's good that the Australian Law Council is doing these presentations and expanding and exposing a number of issues that can assist everyone. So thank you very much.
Thank you so much, Adrian. So look, with that,
can I just one last thing? Can I just
Sure.
mention one last thing? And that is in the Electronic Transactions Act, Section 15C actually identifies that transactions having a transaction occurring without any human intervention will not in itself invalidate that transaction or a contract based on that. So Section 15C is very interesting. It was originally started under Section 14 of the UETA, the Uniform Electronic Transactions Act in the United States under the Uniform Commercial Code. So Section 15C is also a very important piece of legislation that can help.
Fantastic. Thank you, Adrian. There's your little hot tip for the audience. So I just wanted to thank all of our speakers. So we had Dr. Mark, we had Tom, Aaron, Marta, Natasha, Angelina, and Adrian. Also, a big thank you to Jessica Morrow of the Business Law section of the Australian Law Council. And that's it. Thank you so much for joining. And if you put any questions in the chat, we'll be looking at doing future sessions that may be able to answer some of those questions. So please lean in, get involved, and be part of the conversation and finding the solutions for how we bring smart legal contracts to life. Thanks very much.